Hai capito? Allegra c'è un po' di delay, quindi...
So I am continuing research here with a conference for research that I was studying for very
Sì, no, infatti, no, perché se devo leggere qualcosa là è...
That's true.
Yeah.
Yes. Yeah. Maybe we can start now and we will find after. So good evening everyone and welcome to another Belgrade legal theory group meeting. The last one during the ongoing Belgrade Legal Philosophy Week that is taking place here at the University of Belgrade. My name is Alessio. I will be your moderator today. I'm a candidate at the University of Belgrade. The meeting will have the usual form with the presentation lasting around 30 to 40 minutes, after which we will have some time for the discussion. Today's topic, judicialization of rent controls in Europe, is not only very pressing and current, but also practically oriented. And it is part of the European Research Council starting grant project Habitat that our today's speakers are implementing from this year. It is my great pleasure to inform you that today, for the first time in the history of the legal theory group, we have 3 speakers. In alphabetical order, we have Elena Ferrari. She's an urbanist. She finished her PhD at the IUAV University of Venice. Currently, she's doing a postdoc within the Habitat project at the University of Genoa. Then we have Allegra Grillo, who obtained her both bachelor and master degrees in law from the Bocconi University. And she's starting her PhD studies also at the University of Genoa within the ERC project. And last but not least, Professor Alessio Sardo, full professor at the University of Genoa and a principal investigator of the ERC project Habitat. Previously, he was an Alexander von Humboldt Fellow at the University of Heidelberg, researcher with grant and lecturer at the Bonn University, and a research visiting associate at the London School of Economics. So, dear colleagues, without further ado,
Heartfelt thanks, Anna, for this wonderful introduction. We're all very grateful for being here, for the nice invitation, and would like to thank Anna, Mina, Boy, Julieta, Professor Mio Draghi, all of you for being here. The topic of our presentation today is the judicialization of rent controls. We're speaking about rent controls, and this is, of course, as unexplained, part of a much larger project named Habitat. This is the acronym and deals with how European big cities and legal system trigger urban inequality and inquiry into law and economics. So we use law and economics methods. Generally, we applied comparative law / legal theory, general jurisprudence, if you prefer to use this label, and applied economics and statistics. So this is what we're trying to do. We're talking about rent controls, and this is a nice way to start because rent controls are often, well, they've been analyzed by urban scholars, by architects, by economists, but there is a huge gap in the literature because there is no analysis of the case law on rent control. That's why we started there. And this is a fundamental topic because rent control have always been perceived since World War I as tools for ensuring affordable housing in tight markets or in condition of housing shortage, And activists see rent control or conceive rent control often as a way, as policies for containing urban economic inequality and as cornerstone of housing justice. By contrast, the topic is highly controversial because economists, particularly neoclassic economists, see rent control as tools that are aimed at correcting supposed market failures, but they generate or trigger other forms of inefficiency. Arguments like the sitting tenants, the arguments from decay, and other problems that we have analyzed in our paper, but that will not be the object of today's discussions. For sure, rent controls from the economics perspective introduce new focal points for market equilibria formation. So they introduce rent cap or they introduce some rent stabilization mechanism, and of course this determine or generate new equilibria in the market. Of course, as hinted earlier, some consider these regulations are inefficient. So it's worth exploring this issue. Particularly, a brief note on the research design. On the research design is the following. Basically, our research objective is to explore rent controls. We do some conceptual analysis, so we explain what a rent control regulation is. It's something much more complex than a rent cap or a rent freeze, as one might intuitively think. And then we explore the judicial response to rent control. What we've done, we have selected several courts. If you're wondering the discussion, we can explore the reason why we selected this court and the argument that justified the case selection. What happened is basically that our research hypothesis was actually tested and it proved correct. A robust conception of property rights protection combined with a market-based approach underpins the judiciary assessment of rent control in Europe. So this is the result that we have. Market value is often taken as a benchmark for fair price in rent control cases. So the fair price for the European judiciary is the market price, and judges often downplay the social function of property. The outline of the talk is more or less the following. I will say something about methodology, then Elena will explain rent control as regulatory cluster, introducing the conceptual analysis on regulatory cluster, something that is used by the economists but not defined. Then I will focus on the case of the European Court of Human Rights. Allegra will take over and discuss the Italian Constitutional Court and some cassation court cases. If we have time, then the word goes back to Elena. She will focus on the case that promoted the return to rent control debate in Europe, that is the Mietendeckel case by the German Federal Constitutional Court, and then we'll have some final statistics and concluding remarks. We've explored up to now more than 200 cases. This is really a pilot study, guys. We started in July, so just doing the recruiting, getting the project started. So these are really preliminary results. It's the first time that we present them, and we're glad to do this in Belgrade. We have explored more than 2,000 cases. We've performed standard semantic analysis on case law on the major databases. Then, of course, we cross-check we looked at the academic and gray literature. We set further exclusion criteria because we didn't want to tackle issues that deal only indirectly with the validity of rent control, so taxation that do not impinge on the economic assets of the landlords, or other topics that are touched only tangentially upon rent controls were excluded. Then, of course, we perform interpretive analysis. We can do statistics and econometrics, but it's all based on previous legal analysis and argumentative analysis of the judicial decision. And then we focus particularly on the outcomes and the type of clause that was actually mentioned by the judges. Now the word goes to Elena. Thanks.
So thank you a lot. So following what actually Alessio said, I will just introduce first of all the concept of rent controls that, as Alessio also said, were first introduced in Europe and worldwide after the world wars, what we refer as first generation rent controls. So today, most of the European system rely on what's called second generation rent controls, which are complex normative frameworks that, beside protecting tenants from rising rent prices, they also have a substantial return on investment of lending. Second generation rent controls are not simply rent ceiling, as also said, as also Alessio stressed, but a complex regulatory cluster. So, and we are here, we have a group of regulations and rules and policies that are interconnected and related to a particular domain or area of governance. So the concept of regulatory cluster presupposes that there are several sets of norms, principles, and policies that interact within a specific normative systems. And normally the regulatory cluster is described or characterized by the following elements here listed. So a rent ceiling or controlled rent price, rent increase limitation, so most rent control cluster place limitation on, for instance, annual rent increase for property located in certain areas. Can I move on? Yes. No, it's okay. The domain of application, so for instance, normally applied only to a portion of housing stock, and time frame of application, limited period, an oversight board, so several regulation endorse a rent oversight board or rent stabilization board, some exceptions and enforcement mechanism and penalties. So for instance, landlords who violate this regulation may pay some fees.
Maybe move the mouse.
See if it works now.
Someone click into the mouse. Yeah.
So here we are. Here we show how the application of this rent control regulatory cluster in the French case of encadrement de loyer. So rent control regulatory cluster might be introduced by complex laws. So in this case, the encadrement de loyer is introduced by Loi Allure in 2014, and then reinforced by Loi Elena in 2018. So aiming at contrasting excessive rents and promote access to affordable housing, the encadrement de loyer proposed a residential rent ceiling measure called plafond, which is that function on based on several variables. For example, the number of the rooms of an apartment, the location, and so on. The rent increase limitation is applied on some certain zones. So that in France are 28 cities classified as area with high rent potential. So zone 10. The ceiling and rental increments of the lease are determined by a certain index that we see in the IRL. So it has a limited time frame of application, a rent are fixed by a prefectural order, and the rent ceiling takes the market value as a benchmark and allows for exceptions, so rent supplements here, when the property has an exceptional location or height and amenities. The cluster includes remedies too, so the prefect mayor can require the landlord to reduce the rent and repay the tenant and any overpayment. If the law refuses, the prefect or mayor can order to pay an administrative fees. And then I pass again to Alessio.
Thank you, Elena. Elena is an urbanist, not a lawyer, so thanks for the very precise explanation of rent control. So these are really complex regulatory clusters. They're complex normative systems, but surprisingly, most of the cases, judges deal only with 2 or 3 elements of this regulatory cluster. One of these elements is clearly the rent cap or the rent price. So how much the rent control diminishes the price compared to the market value, as we will show, or they deal with problems connected to eviction, whether the eviction orders in the case of rent controls can be suspended or the extension across time over time of the rent control measure. So normally we as a jurist, as a urbanist, before starting this paper, we thought, like probably tenants will apply to courts, and probably fundamental rights courts like the Bundesverfassungsgericht, the German Federal Constitutional Court, the European Court of Human Rights, will side with tenants. That's what we expected, because these are perceived as the vulnerable subjects, and most of the time they are. But that's not what actually happened. So I'll start with the European Court of Human Rights, which is the most striking case. Normally, cases dealing with rent control are assessed under Article 4, the right to protect private and family life, and Article 1, Protocol 1, protection of property. The Strasbourg court is reluctant to assess rent control under the equality clause, and this is already striking. They don't want to touch the word equality or the concept of equality when they deal with this regulation. They claim explicitly in all the cases that we have explored that the European Convention of Human Rights does not contain a positive right to housing. So the state, it's free to decide, or in any case, there is no positive right to housing to be claimed by the tenants, and they downplay the social function of property. Again, striking, most of the applicants were landlords, not tenants. Only a couple of cases were actually had as applicants tenants, and the outcome was all the time, or 90% of the time, in favor of the landlords. We'll come back to the statistics at a later point before concluding. Many decisions were taken this has an historical explanation. We have no decision before the 1980s. 1980s are exactly the moment in which in Europe we started with the privatization process, with the deregulation process, and we moved towards a free market approach, post-40 cities, Thatcherism, and so forth. And before that day, we have no cases on rent control. And most of these cases are from the 90s and the year 2000, deal with rent controls endorsed in Eastern European state or Southern European state, where the court that had like strong tenants protection or socialist or quasi-socialist system for regulating tenancy, and the court somehow accelerated as a body of the Council of Europe this transition to a free market economy. Let me show you just a couple of cases. Again, here, Bito and others, it's a case from Slovakia. Again, there was a violation of Article 1, Protocol 1. Again, the applicant was a landlord, and the court recognized that there was an interference with property rights, and that Slovakia state failed to strike a fair balance by endorsing a rent control scheme that reduces the rent to 26% of the market value, which was too low. Please notice that the parameter, that the benchmark is the market value. The rent to value gap was too high, and this is the argument of the court in Bito. Anthony Aquilina, 2014 case that where you have Malta regulation that has been challenged again by landlords, again violation of Article 1, Protocol 1. There is an interference with property right, and the court stressed that there was no fair balance because the landlord was forced into an indefinite relation of landlord-tenants, and there was no possibility or no probability that the tenants would leave voluntarily, or it was remote due to the state of uncertainty and the low rent price. And again, the burden on owners was recognized as disproportionate. And then Melaker and others is the only Austrian case, no violation of Article 1, Protocol 1. So this is telling there was an interference of property right, but why the court considered there was no violation of Article 1, Protocol 1? Precisely because the price of the rent was not disproportionate with respect to the market value. Article 14, again, was explicitly considered as redundant in this case.
Now we will look at some national legitimacy court, in particular the Italian case and the German case. To discuss the Italian case, we need to describe first the Italian regulatory cluster. In Italy, a free bargaining system and a rent control stabilization mechanism coexist. In other words, before entering into a lease, the two contracting parties can choose whether to apply or not the Fair Rent Act. If they prefer the free bargaining system, it's okay, they will not have any price restriction. But the duration contract has to last 4 + 4 years. Instead, if they prefer to apply the Fair Rent Act, the duration contract will be 3 + 2. And landlord will not be enabled to ask tenants to pay in advance more than 3 rents. And moreover, the price will be subject to a low rent cap, which is established through collective agreement between landlords and tenants association. Finally, there is the rent stabilization mechanism, which provides that after the first 4 years, the rent cannot be increased more than 75% of cost of living. Well, the Italian Constitutional Court has occasionally been called upon to address rent controls that accrued within the regulatory cluster. Unlike the European Court of Human Rights, the Italian Constitutional Court has sought to address rent control under the Equality Clause and the Property Clause at the same time. But by contrast, a similarity with the European Court of Human Rights is that the majority of the petitioner plaintiff raising questions of constitutionality are landlords. Well, rent control sometimes have been rejected, sometimes have been upheld. But what we notice, analyzing several decisions, is that the arguments of the court reveal a pro-market approach. So balancing landlords' interests with tenants' interests, making a trade-off between the right to housing and property rights, the court focuses on the commodity function of housing rather than the social function of property and dwellings. As a result, and as a proof of that, the court's decisions are based much more on private law regulations and principles rather than just belonging to public law. So, in this striking decision, the court was decided whether or not the lawgiver should have regulated the rent contract as a contract with an unlimited duration and empower the landlord to regain the enjoyment of property only in case of a justified reason. Well, the court obviously said no. And so the court responds negatively, but admitted that the right to housing is essential, but rejected the idea that the right to housing is a precondition to the other inviolable rights. What is more is that the court declared that Article 47 is aimed at promoting home ownership. As a result, the rent control regulatory cluster must be interpreted in the sense that encourage savings because they permit the access to home ownership. We don't have to promote an unlimited tenancy relationship. As a result, the right to housing is bundled with home ownership, and it's up to the lawmaker to implement the social function of property. The political question emerges also in the second case, because the court stated that introduction of exception to rent control are a political question. The case concerns a little village called Campione d'Italia, which is close to the Italian-Swiss border and whose economy is tied to Switzerland. So, because of that, the Italian rent control was lower than the Swiss average cost. So, the applicant claimed that there were the two different cases, Campione d'Italia and the rest of Italy, were treated in the same way. But according to the court, the case should not be seen as a violation of the quality clause, but as a decision of the policymaker to establish a general national rule for purpose of conformity. Now, if we look at the Cassazione case law, we will not find any tension with the Constitutional Court case law. Because at the end, Cassation Court focuses much more on eviction procedures and to process to determine the fair rent price. Without explicitly interpret or define the right to housing as a concept. But if we look at the relationship between tenant and landlords, what we see is that the Court of Cassazione placed a significant emphasis on safeguarding landlord interest in securing court's order against debtor, against the tenant, even prior of the non-performance of the tenant himself. Now we will see the Berlin case.
So thank you, Allegra. So let's turn to the case of Germany and specifically the case of the Berlin Rent Cup, a recent case of the Berlin Rent Cup, so-called Mietendecke, which is particularly emblematic for discussing the constitutionality of rent controls in Europe. So starting from the federal level, I will try to summarize, and Alessio, please feel free to add if you want or if it's not clear.
Just a tiny little detail, we explored all the jurisprudence of the German Federal Constitutional Court on rent control. The population is around 50 cases. We selected 20 more pertinent cases. So we explored everything. We're focusing on just one specific case because of time, basically. Thanks.
Okay, so starting from the federal level, so the German Federal Constitutional Court, briefly, so rent controls are allowed, but the judge may not prevent the landlord from enforcing a legally permissible rent increase. Then public and private law are equity ranked. So, for example, the German Federal Constitutional Court has declared that there is no priority between private and public law when both regulate property. In this sense, the legislator has a duty to give content and limits to the property. It does not matter if the configuration and the restriction of the property is for private or public law. The German Federal Constitutional Court has decided that at least 10 major case studies concerning rent controls between the 80s and the 2021. Almost all cases have been assessed by solely the Article 14, paragraph 1, which regulate property, inheritance, and expropriation. Only one case was addressed under the Equality Clause, Article 3, paragraph 1, in conjunction with the Article 88, protection of civil population in state of tension. Secondly, the fair price is the market value. So property rights do not ensure the maximum profit of lenders, which can be excluded by rent controls. But the fair price is standard comparative market rent. If it is lower, the economic loss of the lenders is disappropriate or excessive. So now let's start to framing like the current or recent scenario of Berlin, in which rent control measures are particularly meaningful especially considering that 85% of Berliners are living in a rental housing, but also considering the urban history of Berlin, and particularly considering that Berlin is facing and has faced a transition from a shrinking city toward a more compact one. So actually, this is something that is occurred as a process that occurred in the wake of product privatization of public land, and also the densification of the urban fabric, so urban densification, which actually is a strategy that's pursued also by the Berlin Senate for the future development of the metropolis. So actually this transition meant that the average cost in specific in the inner city, in the central district, has increased by the 75%. The social and the stock of social housing is decreasing. But specifically central district, for instance, Köln or Frankfurt, which is characterized by low-income population, and particularly affected by this phenomenon of gentrification, that are continuously exposed to risk of displacement. But we have to consider also that Berlin, in its recent history, has been advertised, or as some scholars can argue, has been sold with a slogan by the city itself, like Berlin for but sexy, so promoting the city for artists and creative industry, and in fact extracting foreign investments. In all this scenario, we have to consider that activism has played a key role as a sort of movement of resistance, of grassroots resistance, but that has actually characterized all the recent development of the city, and has a strong influence on policies and development strategies. And we also see how, in the case of Mitteldecke, it was particularly relevant. So here are just a couple of graphs, like describing who actually owns Berlin, who actually owns the partners of Berlin, so also privates, and how Berliners are living in rental housing. Another graph just showing that also present they are still increasing, it's like units of and affordable units are increasing. And then, so actually, the Berlin Mitteldecke came into force in 2020 and was strongly advocated by, at that time, Senator Katrin Lomscher from the Left Party and her coalition, and was applied to the city to the land of Berlin. It included rent freeze, allocation independent rent cap for letting, statutory ban on excessive rent, which could be reduced. But what did the application of this of the Mitteldecke mean actually for Berliners? Especially, as I stressed before, in the inner city district, the rental prices in some part of the city, in some buildings specifically, decrease of the 45%, so increase sharply. And as the law was applied independently by the location, it would have redistributed housing affordability across the metropolitan area or the land. But we know that Berlin, I mean, like the Berlin Mitteldecke was a short history. And in the March 2021, the Senate of the Federal Constitutional Court declared the Mitteldecke incompatible with the Article 74, 72 of the Basic Law. So the act was null and void, for it violated the vertical distribution of competencies between central state and the lender, so the region. So the main argument, and again, Alessio, if you want to add something, like, no, feel free, because I think it's relevant also if you want to start something. So the main argument actually was the concurrent legislation. So if the federation is regulated by Article 74, and so if the federation is in power, then the lender cannot conflicting measures. So the protection, the rent cap and the federal rent break regulate the same issue. They protected of tenants from excessive rents for unrestricted housing. However, Multidec announced the leeway left to the party that introduced a parallel rent law, at the state level. So the Mitteldeckel in Berlin modifies the balancing of interests established by the federal law.
Just a tiny little detail. It looks like a formalistic approach. They say, okay, this is competence of, like the nation, not the lender or the metropolitan city of Berlin, because we already endorse, like a second generation rent control at the national level, which is the Mietpreisbremse. They say, they add something. They said, okay, this is incompatible. So there's an antinomy between the local regulation, the local policy, and the national policy. And the local policy, and this is the important thing, deviates from the parts from the general rule in a way that it's disproportional and imposes burdens on landlords. So there's this little part that is right behind the formalistic argument that should not be over. Please go ahead. The presentation was accurate.
Yes, but it was actually important what you remarked, and then then there is a couple of slides on what's left. So what left in this situation. So what can be done for what concern the rent control? So subsidized rental rates are available. There is a so-called Milieschutz, which is a measure which grants to the Berlin district the responsibility of identifying some areas in the cities, like social preservation areas, whose rent regulation is subjected to the free market. But although the rent prices in Milieschutz preservation area most of the time is effectively regulated, the provision did not in recent history prevent the speculation of several hundred door housing or create new houses supply. Then there is the possible more social housing. So Berlin has a special regulatory mandate within the limits described by the federal law or the Mietpreisbremse, so literally rent break. And actually, the last, just to conclude, the Sozialisierung or the socialization was actually what activists, taking into account in this scenario, the socialization is what activists appealed within the referendum in 2000, that passed in 2021. Called Let's Expropriate Deutsche Wohnen and Co., referring to one of the main real estate companies that own several housing units in Berlin. So the proposal is precisely that of the expropriation of property in private real estate companies through public purchases through cases by the Berlin state government.
Yeah, so again, also in this case, as far as rent control exclude the maximum profitability of the landlord or of the owner or a real estate company, that's fine. Otherwise, there are some problems. We know that we're running out of time, so just 4 minutes and then we'll be done. Just fair price is the market price. It's what is written in all the decisions that we read. Landlords and owners should not carry the burden of a shortage of housing. But where is it written that tenants should basically take that burden? I mean, even with inflation, if you say that, okay, landlords can adjust the rent to the inflation cost, you're saying that tenants have to support or take the burden of the inflation cost. There is no positive right to housing for no one, no constitutional courts. Private law lenses are preferred to public law lenses to read this case. Is that a legal failure? We don't know yet. We will study. Of course, our research has strong limitation. We can discuss about that later. This is just a teaser of what we're going to do in the next 5 years. Just some statistics, just some descriptive statistics. We registered no cases before 60, only a few cases. Till the 80s, you see all cases of all courts are concentrated between 1980s with an increase of the year 2010, 2015, and so forth. Some of these applications are very old, so the courts take like a decade, particularly the Strasbourg court, to decide cases. If you take the European Court of Human Rights and you see the distribution of cases by country, you see that they are concentrated on the Czech Republic, Italy, Malta, Slovakia, and these are the countries where you had like a strongest tenant protection in the system at the time of the decision. If you take the European Court of Human Rights and you see the final decision by year, you see that the trend is confirmed. You have basically no cases before 1988, and most of the cases during the procedure of enlarging the European Union and welcoming the Central and Eastern European state within the Union. This is very striking, the equality clause. So here there is some dispersion of data. So you can see that generally speaking, as Allegra pointed out, but we want to have some evidence that based our hypothesis, you can see that normally the Italian Constitutional Court is more keen to address this issue under the equality clause compared to the other two courts, so cases are higher. But you can see that all courts tend to reject the applicability of the equality clause. So if you see the percentage in which is alleged or basically claimed by the claimant or the applicant, and the result, you see that tendentially they do not consider the equality clause. Here you have the outcome in favor of. By outcome in favor of, we mean that the decision kind of pushes in one way or another the balancing of interests with respect to the policy endorsed by the legislator. So if it's more towards the interest, if the balancing is more towards the interest of the tenants, then it's in favor of tenants. Otherwise, it's in favor of landlord, because otherwise this would not make sense. And you can see that the striking majority of decisions are pro-landlord. And in most cases, there are like landlords that apply. So let's take the delta of the rent cost of apartments. Now let's focus on Berlin, some data on the rent control in Berlin. You see that it was like really effective. Of course, we adjusted it by subtracting the inflation rate early. Data on the inflation rate was taken there. You can see the details on the data. Why? Because inflation rates push the price of rent up. So, of course, you might claim that the increase of rent or the decrease of rent is tied to the increase or decrease of inflation rate, but which is not the case. You can see that even by subtracting the inflation percentage here, you can totally see that there was a negative delta in the case of in the years where they applied the rent control, and then prices went up. This is at the Berlin level. Of course, we explore data and we're developing mapping for the district level. And here it's just one example of a striking district, hipster area of Neukölln, where all the nice hipsters want to live. We like Neukölln. She lives in Neukölln. So basically, prices went down minus 7.95% during rent control, and then up 14 points. So that's striking. Of course, this is just a little hint of what we're doing. We have done much more, but now at the moment we excluded some data and statistics from this presentation. Just to let you know, we have performed a preliminary predictive study. The results were really striking, but we're cleaning the data, we're harmonizing things, so it's not we're increasing the data sets. So the sample was all courts excluding the cassation. There were missing information on the cassation court. And the preliminary analysis shows that cases where the legitimate aim category and tenant protection were alleged. So all the cases where the court said, oh, the rent control pursues a legitimate aim and says, well, tenant protection is something that should be answered. It was claimed by the parties in the case, and they said also, you know, like states or courts at the national level or governments at the national level have a wide margin of maneuver, have a probability of tenant winnings lower than of landlords winning, ceteris paribus. So we keep all the other value constant. And also preliminary analysis shows that for cases when the interfering of the right to housing was registered, again, there was a lower probability of tenants winning than landlord winnings, ceteris paribus, where the benchmark is the probability of tenant and landlord winning with reference to all other legitimate aim category. But we're still working on this data, so I hope that we'll be able to show you this next time. Thank you so much.
Thank you. Thank you. This was really interesting and informative presentation. You gave us a lot to think about, and especially in our national context of, I'm referring, of course, to the enormous recent increase in rent prices in Belgrade that happened maybe a year ago and was caused mainly by geopolitical factors, but I'm sure we will hear more about that during this conference. With that said, I open the floor for comments and questions. Domingo, let's start.
Okay, with Mila.
No. You're a guest.
Thanks. Okay, so fascinating presentations. Thank you very much. For me, I come from Portugal. The housing market is crazy there, especially in Lisbon and Porto. And actually, a law changing the current regime has just been passed. It's waiting for promulgation from our president. But since he just dissolved parliament, he has other things on his mind. But we can hope it's coming soon. And my two questions are. You mentioned semantic analysis. So one, I would like to know how are you doing the semantic analysis, especially if you're using algorithms? That's my main concern. What is the second one is what is the scope? I mean, are you going to, because you mentioned there are some graphics with some countries. Is that the whole universe of the study so far? Are you going to, I'm asking this specifically because of one question that you mentioned, which is, and I'm trying to figure out if this is regarding your presentation or the complete scope. You said that you didn't find any housing rights, so the right to housing. And for example, in the Portuguese constitution, there is a housing right. There's a long-standing jurisprudence by the Constitutional Court. Some decisions actually mention the social function principle, which is interesting. So I was wondering what's the scope and if you are going to include other countries other than those you mentioned there. So thank you.
Yes, thank you very much. As explained, this is just a pilot study, so we focused on 5 courts. We added also French decision, which are not in today's presentation. We took courts that had both similarities and differences, like some of them had an abstracto control, other courts, well, they had different procedure. They're all brought together because most of them are constitutional courts or legitimacy courts, as Allegra explained. We're increasing our scope, so we'll focus on Portugal, on Poland, and Holland, I guess. I'm not sure about it. We're still dealing with the case studies, but of course we'll increase the scope of the inquiry. And also we wanted to see, different systems, not only systems that had different courts or different procedures, but also different social welfare system, different types of economies, different regulation of the housing stocks, and so forth. This was our idea. So we're increasing. With respect to the European Court of Human Rights, we think that is the entire population of cases. How we perform the semantic analysis. We have not used any natural language processing or anything of that sort. The reason why we're not using that is that we don't want to give up the idea that this is theory driven and the theory of legal argumentation should be enforced by lawyer. You cannot point out a semantic trigger. In some cases, yes, maybe do balancing, and all the cases where they say balancing, there's balancing. Or you write down a fortiori and you can train an algorithm to do that, but otherwise it's much more complex. You need the human brain to perform that analysis. What we've done, we have developed semantic clusters of all the concepts that are tied to rent control, so mid-price brands, Mietendeckel, and so forth, and we have explored that manually. I hope that this replied to your questions.
Thank you very much.
Before I give a word to Mila, I just want to say it's an option to collect all the questions and then you refer to them collectively after, or you respond one by one.
As you wish.
Whichever.
As you
Mila.
Okay, thank you very much for this interesting lecture. I really enjoyed it. And I think it's really important to speak about this stuff in Serbia because of the things that Anna mentioned, the complete change of the rent market in Serbia, which happened around March last year, so 1.5 years ago, when around 200,000 Russians came because of the war, and they completely changed not only the market situation, the rent situation, but also the complete economical situation. And for example, just one example, they opened around 4,200 companies in Serbia, and majority of them are IT companies. And of course, they were searching for a place to stay, and that increased the demand for renting spaces. And of course, that impacted the price. And what happened? The price doubled. Like what costed 300 euros 2 years ago, now is 600 euros. What costed 500 euros now is 1,000 euros, more or less. And it's the price not only for Russians, but also for Serbian people. And also, since we don't have contracts which are written and there is no rule, any kind of rule regarding how much you can increase the rent, it happened that a lot of the people got kicked out, but just because they didn't have enough money to pay the next month the double price. So, and of course, the debate started, and we even had one really interesting here in the faculty, which I listened. And the main argument against rent control is that, as courts in Europe said, like fair price, the market price. And all of our professors even said, we need to have economy and country where people can make money, and you cannot stop people making money out of their property. But as you mentioned, there are some social factors and social functions of the property, and I'm eager to hear what is the most important argument in favor of rent control, because I'm a big supporter of rent controls because I'm renting apartment here in Belgrade, which is only one part why am I in favor of that. So that will be
Boy, he's a landlord.
yeah, exactly.
He's satisfied with the market
Regulation. And there's also arguments that we are not anymore a communist country and that we cannot make any interventions on the market. So that's also one argument against. And so that will be my first question. My second one, so one really persuasive argument in favor of rent controls for me, but I'm not certain about your opinion. I want to hear that. So Serbian law has fixed prices for some basic products. For example, for bread, for milk, for sugar, for flour. And you cannot sell these products above that price because they're recognized as necessities. Why cannot we say that having a home and having a place to live is a necessity and just implement the same argument? So if you need bread, you also need a home, then there is no any other interest which is like more important than that. So that's all. Thank you.
Exactly. Thank you very much. We discussed briefly about this Russian problem in Milano when we met, also with Anna. That's very interesting. I think we can explore that together. Maybe that would be nice, at least for us. I don't know for you. It will be exploited. But I think that the strongest argument for rent controls is the one that you pointed out. It's the argument that Keynes and others endorsed in the UK when they promoted the construction of council housing, that house is like something that is too important, is an essential good that should be subtracted to market dynamics, and that the right to property does not ensure the right to maximum profitability, but not even the right of using homes and dwellings for rent-seeking activities. Then, of course, you might distinguich between first-generation rent control or rent freeze and second-generation rent controls. There are studies by Kaushik Basu and others that point out all the inefficiencies of rent controls, sitting tenants, spillover effects on the labor market because people that live in a low rent flat have less incentive to accept better jobs in different locations. So you have a lot of arguments developed by neoclassical economists in favor of rent controls, and you have empirical studies that reject that. But I think that, yeah, that would bring us too far beyond our legal dimension. That is already like applied economics. So I think that the legal dimension is that one, that property as a social function, which was pretty accepted in the 70s. Even Tarello wrote a book in 1972 in Italy. Tarello is one of our major legal scholars, was one of our major legal scholars. And a bunch of other people, even in Western country or Mediterranean country, in Argentina, accepted that, property in case of dwelling as a social function. But also John Maynard Keynes, he was no socialist, I would say so. I don't know if you want to add something, because I'm replying, but please feel free to join. Allegra wants to say something.
We discussed briefly before about the idea to the idea to exclude housing from the market insofar as it's essential. And so again, the idea that right to housing is a precondition to access and to satisfy all the other rights, because otherwise you have like a vicious cycle that will not able you to satisfy the free determination and actually your freedom in almost every field of your life.
Can I follow on this? Okay, Mark, wait.
Couple of questions, suggestions. So, but this one kind of being taken over already. I mean, my interest would be in, well, what's the effect of all of this? I mean, I'm totally agnostic on whether it's good or not that courts limit, extend, or introduce themselves rent controls. Let's see how many people have a house with rent controls and how many people and what kind of house and all that kind of thing. Now, this is difficult to assess, but perhaps once you catalog all this data from legislation and court cases, then perhaps you can identify, or if you're lucky to have some sort of natural experiment, right? So one situation in which in one country, for some reason, they randomly introduce rent controls or taking them out in one area only, then this is some kind of a natural experiment, right? Because you see basically all differences after that, you can attribute them to the introduction or the elimination of rent controls. And that would be the kind of thing that I would want to say whether I'm for rent controls or not. I mean, there are theoretical arguments, definitely, and I'm not sure about the empirics. Perhaps there is already a study like that. But you said you want to stick with the more legal. So perhaps one thing would be then to try and identify specific populations and specific scenarios. And there is research on that too. Like, for example, on homelessness and how, I mean, homelessness is generally correlated with other kind of bad situations like addictions, mental health issues generally, obviously poverty, and all of that. There are movements, I know, for example, there's one in the United States, and it kind of spread all over, it's called Housing First, that their thought is that if we give homeless people housing first, then all other problems are made considerably better somehow. So I don't know, perhaps that's one kind of population in which, there's something to say and there's something to do. Or migrant populations, or populations that don't live in settled houses, like Roma populations. What happens when we introduce through legislation some kind of control on how they're renting and the place that they're at and all of that, which is still related to rent controls, but it would, you know, focus on, okay, what happens when we do stuff? I mean, the only fact that this court deciding one way or not, and say we want social functional housing, I mean, yeah, they can say whatever they want. The important fact is how well people live or not. Anyway, that would be my take.
Thank you very much. So first of all, we were not interested in the economic impact on rent control regulation themselves, because this have been widely explored. We were interested in the case law and the case law of higher courts normally. So natural experiment like that, it's not feasible, because you have no data at the sub-district level on of income of the residents or tenants. You have no data on contracts. It's impossible by lack of data. You cannot perform such an experiment, even if ideally it would be great to have a diff in diff with counterfactuals and all sorts of controls, but it's impossible. Simply because of lack of data. Some of them are protected by privacy. You cannot have data on income in Italy, for instance, and in many other countries. There's the GDPR and so forth. So we'll consider that option is not feasible. What the court says, I'm surprised that you as a realist come up with such an objection, because of course what this constitutional courts say have a direct impact on all the functioning of the lower courts, and you've seen the Mietendeckel impact as a constitutive effect of the Bundesverfassungsgericht decision on the Mietendeckel. The law was declared null and void, and you have a 300 euros increase in the new contracts all over Berlin in one fell swoop, and then this applied retroactively because it was declared null and void ab origine. We haven't explored the cases of the Italian constitutional courts on eviction moratoria, but again, the fact that they say that the eviction moratoria during COVID was compressing and was disproportionate with respect to the rights of the landlord and of the owner of a flat, of a dwelling, whatever, had like as an immediate effect, like an increase of action of landlords that were and owners that were applying for bailiff and a waive of eviction. So as realists, we assume that what courts say and what judges say matters and have an impact in real life, or at least.
Just a quick follow-up. Let me qualify that. All right, I totally grant this point. What they do is obviously very important, but in order to evaluate normatively, I would want information, which I totally get the argument that it's not there, but perhaps you're lucky and you find it sometime. I mean, just keep it open as a possibility. That, I mean, the fact that the price increase or decrease, I mean, I don't have, I mean, intuitively, I want prices to decrease, but if that happens, then it's not a good thing. You know, if all prices decrease, it's a relative price that you're looking at, and it's the price of housing. So intuitively, as somebody, for example, I'm renting, so yeah, that'd be good for me. But you know, for the economy as a whole and for people as a whole, I don't have. I'm forced not to have an intuition. I want to see where that leads. I mean, if that leads to people, you know, moving to places where they can find jobs, that's good. If it leads to people being on the street, that's not good. You know. If landlords get richer and then they invest the money and then we have more jobs, then that's good. If landlords invest the money somewhere else, perhaps that's less good.
Yeah, but if in cases such as in Berlin or Milan, prices get higher than the median income, then you have a strong reason for finding some solution. And I'm not claiming I'm not a huge fan of rent controls. I'm pretty neutral and unbiased on that. I mean, what happens is, you know, like you can have other measures, like increasing the social housing stock, giving allowances. I'm not a fan. We were just studying the phenomenon empirically, and this is what we recorded.
Yeah, I would like to add that at the end, rent control is like a subcategory of a bigger regulatory cluster, which is that one concerning housing and the idea to provide a house. And I think that there are many tools, normative tools that we can look at. And all of them, if we look at the whole, they regards many categories, not just like migrants and homeless people. Of course, they are within the focus, but there are other categories. For example, in a city where as Milano, where the average income is lower than a rent, we have problems with like young people at the beginning of a job career because they can afford to stay in the city. So that's the point. I mean, it's not just a problem that regards like the super fragile categories.
Yeah, thank you, Allegra. Would you like a quick follow-up before I give the word to, you're gonna have to start this now?
I will consider.
Thank you very much. Thank you very much for your highly interesting and thoughtful presentation. By accident, I happened to live for a short period of time exactly during this period in Berlin. So I sense what to talk about, and I have just some follow-up, not comments, questions but comments. You took Germany as an example, Berlin, and it's great not only because of the Mietendeckel, but also because Germany has the lowest ownership rate in the whole of Europe. So they have problems and will continue to have problems in that because they cannot change the situation regarding new housing, definitely not in Germany. So my first comment would be that it would be interesting to see if the very strong right to property, which is inherent to the German legal system, whether its interpretation will change in the future due to the mentioned geopolitical reasons. Because also, to be honest, refugees, not all refugees are seen in the same way. Right now, there's still a high welcome culture in Germany. First for Syrians, now for Ukrainians, and especially Berlin is a good example because of its vicinity to the Polish border. So they have a really high influx of refugees. And it would be interesting to see also regarding the whole situation in the world, whether this interpretation will change in the future. So the first comment. The second comment is, right, my experience is that in the rental contracts in this period and also before, in Berlin, there was a clause where it was said that the the price was provisional and that it will adapt after the decision of the court, and it adapted, and then the people there in Berlin had a problem to pay the difference in the prices, and the people had really, really great issues with that. And the third comment would be a parallel trend that is happening, especially in Berlin. Many people have so-called old rental contracts with a fixed rent that cannot increase, and now they often do not want to move out, or if they move out, they under the radar sublet these apartments. So the situation, especially in Berlin, is not as clear as it seems. So this is just some comments on that, and thank you again very much.
Thank you so much. So one of the reasons why we picked up Germany and Italy is precisely because they have inverted percentage of landowner house owners. So in Italy, all the people own houses. Most of the people own houses in Germany. They don't. I totally concur with you, and a lot of people faced hardship after the decision because it happened during the COVID time, so people lost their job. And the last point, I think it's the one that you mentioned is really important. I have not said that all the data we showed, it's about like newly signed contracts. So it's very difficult to map from an economic, and we have a note on the paper, from an economic perspective, from an empirical perspective, the impact of long-term rents, of what are they subletting. Of course, this is an argument against rent control. Like I have a few friends in Berlin, they're IT, they earn a lot of money and they used to live in a rent-controlled flat, and you have the same in New York with rent-stabilized apartments that super wealthy live there, and then you say, okay, then the system is not working, you might do something. And that's one of the inefficiency of rent control. So I think that all the 3 points were really important. Thank you. I don't know if you want to add something. Very good, thanks.
Thank you. I wanted to go back to what Allegra said at one point, that basically the success of tenants, of tenants' claims in all the cases basically was related to the possibility of somehow connected it to some implicit right to housing, even if there was no such right enshrined in the legal documents or legal instruments of that particular country, which is the case in many of European states. But we heard that Portugal is not such case. So obviously, everything depended on what can be put in the balancing formula to use this kind of Alexian approach to the problem, and whether this implicit right to housing can be somehow made in the given circumstances. And what I had in mind is a completely different context, and maybe it would be good to compare it to a completely different context, just to see how the right to housing was basically enshrined, or it was by the interpretation of the Constitutional Court stipulated that some such right exists under the Constitution, even though it was not in the text. This is the situation in South Africa, so it's completely different situation, and this also points to one of the important issues, that is that depending on the circumstances, factual circumstances, this really has a huge impact on how this balancing formula will look like, because South African Constitutional Court employed exactly the equality venue to argue that there is a right to housing. But in their situation, obviously, it was not the case of people, of tenants with a problem of paying rent. It was the case of homeless people, literally homeless people. So those literally living on streets. So in these radically different factual circumstances, obviously this equality venue was much easier to employ and to argue that there is a right to housing under South African Constitution, and they ground it also in the past, in the history of apartheid. So there are a lot of these historical circumstances that basically fueled the case for right to housing. Then they enacted a special law, but by the end of the day, nothing has changed in real life. So that's just at the level of legal analysis. So like 18 years or 19 years after the law, obviously there is still not enough housing for people. So the problem is not solved, but at least we are speaking on this level of legal analysis, which you are interested in. So I was just thinking maybe this radically different context might be of some importance, just to figure out what are the necessary circumstances for this right to housing to be employed, because as you pointed out, the equality venue is completely neglected by the European Court of Human Rights.
Thank you so much. To be honest, we haven't considered about this option, so thank you. We'll have a look, of course, at the South African courts.
Yeah, I think that it's really the point, because the idea is that what we discover is that, in a way, behind the court's decision, there is something taken for granted, which is the idea that the balance is won by property, in a way. But as Alessio said before, during the 70s in Italy, it was not considered like that, and nowadays in Africa, in South Africa, is not considered like that. So I think this is the point to uncover this like secret.
There are also, as far as I can, Bojan will help me, there were certain cases from Croatia, I think, which were right to housing, but the right to housing which was inherited from our socialist era. So during the socialist era here, the ownership was completely suppressed. I mean, it existed, but it was highly suppressed. So there were a lot of people enjoying this right to housing, so privileged housing within someone's apartment. And then after the 1990s, so the complete change of the legal and economic system, there was a huge problem, you know, what to do with these people, because the right was inherited by their relatives and family and so on. So there were some interesting cases. One you will know. I think that you discussed one in this right to reason the judgment. This was just the case from Croatia, as far as I remember.
Yeah, I'm trying to find the surname, but I'm not sure. But I'll send it to you if you didn't do it in this. It was this thing with the inherited housing, but actually their basis of overturning this decision was an eviction that happened without the courts have allowed for an eviction of a tenant or of somebody who was living in an apartment which belonged traditionally to another family, but the grounds for dismissing or for finding Croatia was in this case the right to a reasoned judgment. It wasn't anything, it didn't have anything to do with the basically it's kind of a landmark case because the European Court of Human Rights claimed in this case that the right was violated because the courts haven't done the balancing when they were checking whether he has the right to remain in the apartment or not, or whether he has the right to be in the house or not. So what the Croatian authorities did wrong here, according to the court, is basically they didn't do any proportionality analysis. And we don't really know how would this proportionality analysis pan out, but if it was done by the Croatian authorities, and that's what I wanted to ask you. What are the dominant, because I haven't been reading many of those European Court for Human Rights decisions regarding housing. What were the dominant strategies, argumentative strategies or balancing strategies when the court was ruling in favor of tenants? And what were the strategies when the court was ruling in favor of landlords? I kind of, for landlords, I figured that it must be like an absolute or a high weight of the right to property. Because one of the, for example, when we were doing this, there was a bill proposed last year from a opposition party that was supposed to limit or introduce rent controls in Serbia. But the problematic part there was, of course, it's questionable whether we can administratively do it because it requires a lot of administration, which we don't have separately. But the other problem was one of the often mentioned problems with that is that it could possibly be ruled as unproportionate if you kind of limited or hardly limited the rents in Serbia in the sense that rent controls could be achieved in another way, or right to housing could be achieved by doing these other things. Now, I don't want to deal with societal effects, just on the level of legal argumentation and course argumentation. What do they actually do when they have this, when they favor the tenants who are landlords?
Thank you. We have a quick follow-up.
It's very quick. It's just something Allegra said, and now actually Bojan just touched the same subject. This relates to at least what I know from the Portuguese case law of the constitutional. You mentioned that the rent control is just one of the many options on the toolkit of the cluster of the housing problem. And for example, in Portugal, my question is if you are considering that as some sort of control variant for the study. For example, there are explicit decisions of the Portuguese Constitutional Court saying that they're going to consider some measure of rent control, which is very popular. It was very popular in Portugal in the 70s and the 80s, especially after the revolution. They were in favor of considering it unconstitutional, actually in the balancing test, because given the fact that there were many houses available on the market, the state would have other possibilities to achieve the exact same goal without interfering so much in the right to property. Actually, it's interesting because this is case law from the late 70s, beginning of the 80s, and the measure that was approved in Parliament now, more than 30 years later, it's exactly on those lines. Just saying, for example, if you are an homeowner, but you are not renting your property for more than 10 years, then we have the right to force you to rent, or we rent instead of you and put the money on a banking account, and if you want to take it, you want. And I think that's interesting to understand if the courts are using the same argument as the Portuguese constitutional one does, to say, I'm balancing, knowing that there are other measures that you could have used, so it's a necessity test in a sense.
Thank you, and a quick follow-up from Julieta.
And I apologize, I'll have to leave because I have to teach a class. So.
Okay, can I reply very briefly to this? Just 1 second. Yes, we checked on that. We will have a look on the Lisbon jurisprudence or the Portuguese jurisprudence, and only a few times they endorse explicitly the necessity counterfactual test. Most of the time they don't use it. They just go straight to the third and final phase of the balancing and say that it's insufficient. This is what we've noticed. Just to reply to you, and then I'll go back.
Just email.
Yes, I will. Thanks. We will. Thanks for coming.
Julieta?
No, just to follow up regarding these things, because one of the things that was bothering is was that if you have a case, for example, in the ones that you were analyzing, that the right of housing was recognized, but it was ruled against the tenant. Because, for example, there were other alternatives, or it has been recognized that the state has the responsibility to fulfill the right to housing, and then it was not something that can be imposed in another, for example, citizen. And in this sense, if you have considered expropriation, for example, this is something that was very going on in Argentina when this positive approach to property was being on, and then there were cases of expropriation being discussed. Just
And in Serbia last year, but we dealt with it for now. You have it.
So very briefly, I'll start with Julieta. We're focusing just on rent control on this paper. We have another paper that deals with housing in general and expropriation. The connection of the two. Some of the cases said that the rent control was so intense or so long that corresponded to a de facto expropriation. And so that kind of limited too much, that was disproportionate for the owner. And I'll try to reply to all of you, and particularly to Bojan. First, many cases of all the Polish, Slovakian, Czech cases were cases discussing remainings and inherited rent control schemes. The argument was always basically the same. Wide margin. Article 1, Protocol 1, Article 8 are the parameters. Landlords was applying in almost all the cases. They said wide margin of maneuver of the state. They said legitimate aim. So the state pursued a legitimate aim. And then they said no argument from consensus, no counterfactual, no necessity test in most cases. And then they said disproportionate burden, it limits too much the right to property. But in many passages, and also in determining the damage that should be recovered by the landlord, the parameter was the free market or the market price. And in many decisions, they said, we are implementing a transition to a free market economy or a free housing economy. And then they said, okay, then you're explicitly neoliberal or implicitly neoliberal. So that was the point. I don't know if this replies to your question. Maybe Allegra also can to add something.
There is an interesting case pending before the European Court of Human Rights that I wanted to draw your attention to. I don't know if you have some space for a case study, but this may be interesting. Basically, it regards a legal regulation in the UK that says that it requires private landlords to undertake immigration checks on potential tenants. So you have to be sure that your tenant is fine regarding his immigration status, or otherwise you will be sanctioned. You will be responsible for that, and you can even be imprisoned, which in practice resulted in apparently racial discrimination because private landlords didn't want a priori to negotiate with anyone who was suspicious, which were primarily ethnic minorities, Afro-Americans, or as they said in one article, anybody whose name didn't sound traditionally British. And right now they are claiming a breach of Article 8 in conjunction with Article 14 of the European Convention. I'm really curious to see whether the court will, let's say, talk about indirect discrimination in this case. It is interesting in light of what you said, that it is reluctant to apply Article 14 in these kind of cases. So yes, we will wait and see what the reasoning of the court would be, but I wanted to share that as I think it is connected to some points.
Thank you very much. I was not aware of this case. I don't know whether Allegra or Elena were aware of this case. So thank you so much. We'll ask you reference.
Are there any comments or questions? No.
Just final follow-up. I don't. You say that the courts understand the fair price to be the market price, but it is a parameter, the market price.
The benchmark, yes. And
Yeah,
sometimes
no.
say fair price.
It can be different than the market price, the fair price, even according to the approach of the courts.
Conceptually, yes, but they don't allow this possibility. They either say explicitly that that's the fair price, or they use this as a benchmark for assessing damages.
Yeah.
And
even if they say
and any variation, they don't make. This is something I didn't understand. I mean, it's a clarification point. They don't say you can limit the market price, but you can't limit it too much. They say any variation than the market.
sometimes they use a more sophisticated argument, and thanks for this question. Sometimes they say, okay, the claimant or the applicant is saying that the rent, the rent price, the control price does not suffice to cover, for instance, the maintenance cost as alleged. Okay, so sometimes apparently they seem to endorse another benchmark, which is, for instance, rent higher than maintenance cost. But then when they assess the damage, again, they turn to the market value of the rent of similar apartments in the same area according to an alleged free market, which is, again, a regulated market. It's a standard value and it's counterfactually determined based on who knows which inferences.
The second thing is that that's not the market price in any country, the price of rents, even if there's no rentals. I mean, because there are several things that push the price up, which are clearly the result of state intervention, like, for example, zoning.
The market price in the market price in a regulated market. There exists no free market. So all markets are to a certain extent regulated.
More or less, the price of rents are clearly not the result of market forces only. For example, it's pushed up by zoning, the fact that you have to have building permits, the fact that you have to have regulations of what you build, the fact that you have to comply with all sorts of regulations inside. This pushes the price up and reduces the number of houses, so it pushes the price up of rents specifically. And then several things that push it down, like, for example, public investment. Like, we have a great experience in the last few years of enormous investment in by public authorities on the market, and that has pushed the price up and down a million different ways that it's very difficult to account for. So, but it is important to say that's not the market price. I mean, it's very different from the market price.
I mean, it depends on how you define the market price, because if you define the market price as the market in free, unregulated, as Posner would do, I mean, that's not the market price, of course, but even highly deregulated or non-regulated area, such as a social platform and like digital entities. I mean, there, of course, there are a few regulations and decisions. So there exists no free market in reality, but you have market dynamics that are developed by demand and offer within a specific framework.
Yes.
And that's what we mean as market price in a very applied and microeconomic way, without focusing on the Chicago school.
It's a matter of that when you want to, but I totally get that that's not exactly the direction that you want to go to. When you want to compare the use of rent controls or other measures, when the objective is that people have affordable housing or that they can live in places they like and that they choose themselves to some extent, then you have to compare rent controls with the other things that are going on. I mean, we want zoning laws, of course, because we don't want houses built everywhere. We don't want houses built close to factories. We don't want houses built on rivers, which would happen if we let it go, right? But that pushes the price up. So when you're making the normative argument, we want rent controls or not, you want to say, all right, is it rent controls or is it free building everywhere? You want to build a house right here? Let's do it. No, you don't want that. So perhaps you should give in on rent controls. That's what I was going at. But I see that that's not the paper.
Allegra perhaps wanted to say something.
No, just the point that at the end, the neoclassic idea of market price doesn't exist in reality. So at the end, even in US, you will find this kind of state intervention that will affect the market price. So I think we should understand the idea of market price in relation to the place that we are looking at.
So it's the price determined by the aggregate demand and offer within a specific framework as an equilibria within a general framework. So we define this.
Well, that would include then rent controls.
In some way, yeah.
Rent controls.
Yeah, but
determine the market price.
That's why we said, what would be the price without the market price without rent control?
Okay, yes, no, it's fine. It was point on school. It's just that clearly the price of housing and rents and all connected with housing is far removed in any economy, and for good reasons, than an hypothetical market. Relatively more removed than other goods or commodities like bread, for example, or roses or whatever else. These things are closer to whatever it is that we may need to market price than the price of housing, even excluding rent control.
Think about the jumper you're wearing. That is highly regulated too. Color, bleaching.
Closer to market price, which is a different thing that it's an efficient market, because it is not. And there are monopolies of all sorts that do depend on, that's a whole different business. And it wasn't the point I was trying to make. The point I was trying to make is that there is a sense of comparing different kinds of regulations. And something must give in sometimes, right? So you may not want rent controls because you want zoning laws, or you want regulations on the efficiency of heating system.
So as they define, it's what would be the price according to aggregate demand and offer if rent controls were not present, ceteris paribus, keeping all other things equal. So that's the standard they're using.
One final, just the important disclaimer that I feel necessary for the end is my Indian tenants pay a price way lower than the market price. So, yeah.
You're a good person.
Yeah.
Let's leave it to
Yes. That's so, and I suppose we can continue informally after I finish the lecture. Just briefly, veliko hvala na eksperti Ministarstva prostora koja je sa nama online i koja nas prati. I would like to thank our speakers, to thank everyone for being here with us today, online and in person. We hope to host you again and to hear your research project results soon. We will.
Let's give us a couple of.
Yeah. We will see you all on the next, please. On the next government hearing meeting, but until then, follow and participate in the upcoming Belgrade Philosophy of Law Week activities.
Great.